the Kids Online Safety Act. Sponsored by Marsha Blackburn of Tennessee along with 41 other co-sponsors, this bill aims to require covered online platforms, including social media platforms, to implement tools and safeguards to protect users and visitors under the age of 17. Let's get right into the detailed notes. Title 1 of the Act establishes Kids Online Safety. A covered platform, which is defined on screen, shall exercise reasonable care in the creation and implementation of any design feature to prevent and mitigate the harms listed above to minors. The legislation makes an understanding where this should occur if a reasonable and prudent person would agree that such harms were reasonably foreseeable by the platform and would agree that the design feature is a contributing factor. In the interest of time, see an important note about what has been stated already on the screen above. The bill would require a covered platform to provide a user or visitor that is known to be a minor with readily accessible and easy-to-use safeguards. This also includes an accessible option to limit the amount of time spent by the minor on the covered platform. These platforms would be required to default these safeguard settings to the option that provides the most protective level of control over privacy and safety for that user or visitor. Parental tools for parents to support a user that is a minor have been outlined as well. If parental tools go into effect on a user, the platform must provide a clear and conspicuous notice to the user indicating they have been applied. When a user of a platform is a minor, all the parental tools will be applied by default. Platforms will be required to provide reporting tools to users and visitors, so they may report harms to a minor as well. The bill places time requirements for the substantive response on these reports from the platform. The minimum requirements are shown above. The Act has a ban of covered platforms advertising illegal products to an individual known to be a minor. When implementing the new safeguards and parental tools, info and control options must be provided in a clear and conspicuous manner, have proper controls to enable or disable, and they must all be in the same language, form, and manner as the platform is used by the minors and parents. Finally, platforms are not allowed to use dark patterns. When it comes to a covered platform that is acting on behalf of an educational agency or institution, they would provide these safeguards and parental tools to the agency or institution, not the user or visitor. The effective date of all this would be 18 months after enactment. We will now discuss the policy's disclosure and transparency. The legislation requires covered platforms to provide clear, conspicuous, and easy-to-understand information about the safeguards and parental tools prior to registration or purchase by an individual that is known to be a minor. When the user of the platform is known to be a child, the platform is required to provide information about the parental tools and safeguards to the parent of the child and obtain verifiable consent. Disclosure of the covered platform's info about policies and practices, along with how to access the safeguards and parental tools, shall be located at a prominent location which can include a link to a web page. This act also outlines policies surrounding transparency. It requires covered platforms, no less than once a year, to issue a public report based on an independent third-party audit of the platform. This public report only applies to certain covered platforms. The public report from the platform is required to include an assessment of the extent to which the platform is likely to be accessed by minors, a description of the commercial interests of the platform, an accounting of the number of users known to be minors, the median and mean amounts of time spent on the platform by minors, and amount of content being accessed by minors that is in English, and top 5 non-English languages used by users accessing the platform. And finally, assessment of the safeguards and parental tools and representations regarding the use of the personal data of minors. This public report will also include evaluations conducted by the platform. These include assessment based on aggregated data on the exercise of safeguards and parental tools, description of whether and how the platform uses design features that increase, sustain, or extend the use of a product or service by a minor, description of whether, how, and for what purpose the platform collects or processes categories of personal data related to minors, evaluation of the efficacy of safeguards for minors and parental tools, including any issues, and an assessment of differences of these across different English and non-English languages. Each public report of the platform must include, in English and top 5 non-English languages used for access from the U.S., the following: description of safeguards and parental tools, description of prevention and mitigation measures the platform may take in response to the other assessments conducted for this report, description of processes used for the creation and implementation of any design features that will be used by minors, description of handling user reports which were discussed in our previous video, and finally, the status of implementing prevention and mitigation measures identified in prior assessments. The bill also takes steps to ensure this report safeguards privacy information of users. Next up is market research plus the age verification study and report. Covered platforms of this act shall not conduct market or product-focused research on a user or visitor that they know to be a child. When it comes to a user or visitor that is known to be a minor, they may conduct market or product-focused research with verifiable parental consent. Moving on from market research, let's break down the section outlining the age verification study and report. This act would require the FCC and FTC to conduct a study evaluating the most technologically feasible methods and options for developing systems to verify age at the device or operating level system. The study must consider the following: benefits of creating a device or OS-level age verification system, what info may need to be collected, the accuracy of such systems and their impact or steps to improve accessibility, how a system could verify age while mitigating risks to user privacy and data security and safeguarding minors' personal data, the technical feasibility, and finally, the impact of different age verification systems on competition. A report of the results of the study is due to the Senate Committee on Commerce, Science, and Transportation and the House Committee on Energy and Commerce 1 year after the enactment of this act. Let's now discuss the guidance provided by the FTC and how this act would be enforced. No later than 18 months after the enactment of this bill, the FTC shall issue guidance surrounding the policies implemented for kids' online safety. This guidance would provide information and examples for covered platforms and auditors that includes the following: identifying harmful design features, preventing misuse of parental tools, best practices for privacy controls, age inference and identification, evaluating safeguard effectiveness, and expanding parental control options. This guidance should also provide clarification on what types of conduct do not violate the Act's intent to protect minors from manipulative online practices, including minor UI experiments, algorithms out of a platform's control, and default privacy settings. Guidance provided by the FTC must also include info to help platforms understand when the FTC would determine the platform had knowledge fairly implied on the basis of objective circumstances. Any guidance provided by the FTC has clearly defined limitations and use of enforcement actions, as shown above. Now let's direct our focus on the overall enforcement of this policy if it is enacted. Violations of this title will be treated as violations of rules against unfair or deceptive acts under the Federal Trade Commission Act. The FTC is granted full authority to enforce this title using its existing powers, as if this title were part of the FTC Act itself. A state's attorney general can also enforce parts of this act. If the Attorney General believes the platform has violated sections outlining safeguards for minors, disclosure, or transparency, they can bring a civil case in state or federal court on behalf of residents. They can seek to stop the violation, force compliance, or get compensation for affected residents. Before filing, the Attorney General must notify the FTC, which then has the right to step in and join the case. The Council proposed would provide Congress with recommendations and advice relating to the safety of minors online. These include the following: identifying new or current risks of harm to minors, recommending methods for assessing, preventing, and mitigating harm, recommending methods and themes for conducting research, recommending best practices and clear technical standards for transparency reports and audits. This council will not be subject to the Federal Advisory Committee Act. Established in 1972, this law requires advisory committees established or used by the federal government to operate transparently, with open meetings, public records, and balanced membership, unless explicitly exempted. The council would be made up of 11 total members. 3 members appointed by the President, including the Secretary of Commerce and the Secretary of Health and Human Services, or a designee of either secretary. 2 appointed by the Speaker of the House. 2 appointed by the Minority Leader of the House. And 2 appointed by both the Majority and Minority Leader of the Senate. There are some requirements when it comes to who is appointed. The council must consist of 1 member from each of the following: an academic expert, a researcher, a parent, a youth representative, an educator, a representative of online platforms, a representative of online video games, a state attorneys general, and representative of socially disadvantaged individuals. Once the council is fully appointed, it will select its own chair and vice chair. These appointments are required no later than 180 days after enactment of the bill. No later than 1 year after the first meeting of the Council, a report is due to Congress that provides a summary of the work of the Council and any preliminary findings. Then, no later than 3 years, a final report is due to Congress. This report provides a detailed statement of the findings and conclusions, dissenting opinions of any member of the Council, and recommendations for legislative and administrative actions. After the submission of the final report, the council will be terminated within 30 days. Beginning 1 year after the enactment of this bill, online platforms would have specific requirements to use an opaque algorithm, an algorithmic ranking system that determines which information is shown to a user based in whole or part on user-specific data that is not expressly provided by the user for that purpose. The first requirement provides the platform's users with the following notices. A notice that the platform is using an opaque algorithm that uses user-specific data to select the content the user sees, and the second notice is within the terms and conditions. This second notice includes what is used by the algorithm, how data is used and collected or inferred about the user on the platform, options available on the platform to opt out or modify the profile used by the algorithm, and any metrics the algorithm is designed to optimize. The second requirement is that the platform enables users to easily switch between the opaque algorithm and an input transparent algorithm. This option is an algorithmic ranking system that does not use user-specific data to determine which information is shown to a user on the platform, unless provided by the user to the platform for that purpose. This includes user-provided input and preferences, including search terms, filters, speech, location and session history, current approximate geolocation info, and finally, who the user is following, subscribed to, or other content on the platform the user has selected. This data does not include history of the connected devices such as web history, geolocations, physical activity, device interaction, and financial transactions. It also does not include inferences about the user or connected device of the user. Platforms would not be required to disclose any trade secrets or protected IP, confidential business information, or any information that is privileged. A user's decision to utilize an input transparent algorithm cannot result in the denial, charging of different prices, or condition of the portion of the platform adjusted to the different algorithm. If the platform is acting on behalf of an educational agency or institution, then the requirements stated before would go to that agency or institution, not the user. Enforcement of this policy falls under the FTC. Violations of this policy will be classified as an unfair or deceptive act or practice. Our breakdown of the Kids Online Safety Act is now complete. As it is currently with its committee, we will keep you up to date if items change. If you have any questions, feel free to ask. Follow Newt, your source for clear, fact-based legislation breakdowns.